It's good to see so many of you here again. Welcome back to the seminar series on natural law foundations and applications, and very warm welcome particularly to anyone who's joining us for the first time from wherever you are in the globe, on the globe. And yes, I should say I've often noticed that the concept of natural law, the idea of natural law, is one that attracts many people of diverse backgrounds, not just Catholics, though often Catholics. And at the same time, a part of the idea behind this series was to show that natural law isn't just one thing, either in its concept or in its application. It's really I would say a family resemblance of many different approaches of ethics, of study of sociology, law, whatever it is. So as the title of the seminar series suggests, Foundations and Applications, we've kind of moved on to the application side, not that the two are always neatly distinguished from one another. So today we're very pleased to have Dr. Dominic Burbidge giving a paper on natural law and social science methodology. Dominic is the founding director of the Canterbury Institute in Oxford, and he's also a lecturer in politics at St. Peter's College and a research coordinator for the Oxford University Faculty of Law. So without further ado, I hand you over to Dominic, who will talk to us about natural law and social science methodology.
Thanks a lot, Michael. Thanks for this great series. I've really enjoyed listening to everyone so far. I don't think I'll enjoy listening to myself too much, but I look forward to the Q&A. Nevertheless, I will share a PowerPoint as I go, and just keen for any sort of feedback and thoughts about this topic, which I find to sort of open up quite a few questions, or which I try to navigate some answers, but I'm very keen as a sort of project going forward to get as much sort of input as possible. So thank you in advance. The central case of law, this term central case of law, is suggested by John Finnis to be the ordering of society through practical reasonableness. Law involves a moral ordering of society and not merely positive regulation. So it's impossible, he believes, for jurisprudence to take a completely value-free stance. So to quote, no theorist can give a theoretical description and analysis of social facts without also participating in the work of evaluation, of understanding what is really good for human persons and what is really required by practical reasonableness. This term social facts actually building on Hart and Raz in terms of a more sociologically receptive approach to jurisprudence, of seeing how the law actually plays out with respect to social facts, but also combined with attention towards social sciences and the way in which we understand how society is, aside from the question of what a legal system is. So when considering what is really good, therefore, the central case of law is something that can be known and aimed at. And obviously in discussions of ethics and philosophy, we tend to look at whether it's something we can aim at, natural law, or natural law theory, but it's also something that can be known empirically through the senses. So it is not an ethical code against which laws can be evaluated, but a holistic end for the legal system, a position at which the use of practical reason is most realized. Indeed, the central case of law takes on a holism that admits of different societies' different needs. It is prescriptive, but dependent in its prescriptions on a society's existing normative structure. So to quote again from Finnis, these are from when it says 2011, it's from Natural Law and Natural Rights, second edition. To quote, the central case of law and legal system is the law and legal system of a complete community, purporting to have authority to provide comprehensive and supreme direction for human behavior in that community, and to grant legal validity to all other normative arrangements affecting the members of that community. So this idea of a central case, also sometimes described in terms of focal meaning, draws in its approach from Aristotelian natural philosophy, which sees the thing according to the end of its being and develops from these observations an understanding of the species of something. So the end of law is the ordering of society. It's therefore a type of practical reasoning that applies itself to the good of the whole society, supreme in the sense that it provides overarching direction to human affairs and is the last legitimate resort for resolving disagreements. A law is part of the central case if consistent with practical reason, with peripheral cases, those out of sync with this demand. But what is the practical? And a part of the difficulty sometimes in articulating the central case of law lies in the difficulty of defining the practical, a kind of general lack of knowledge about phronesis within the legal community, the legal academy and law schools, but also difficult in terms of translation between contemporary social theory and Aristotle. So for looking at the term practical, Finis defines it as, by practical, I do not mean workable as opposed to unworkable, efficient as opposed to inefficient. I mean with a view to decision and action. Practical thought is thinking about what one ought to do. Practical philosophy is a disciplined and critical reflection on the goods that can be realized in human action and the requirements of practical reasonableness. So when we say that descriptive theorists whose purposes are not practical must proceed in their indispensable selection and formation of concepts by adopting a practical point of view, we mean that they must assess importance or significance in similarities and differences within their subject matter by asking what would be considered important or significant in that field by those whose concerns, decisions, and activities create or constitute the subject matter. So if we look at the subject matter as the making of laws, then of course it's those concerns, decisions, and activities of the body politic. So it also may help us understand the practical. This quote comes from Finis's book on Aquinas. The plan, policy, and intention which others can be told about or told to follow or come to understand without being told is itself practical. It is about what to do. In order to achieve this, I or you or we should do that. It is not about what is the case, nor even about what will be the case. It is about what is to be the case. Is to be, should be done. A prescription, and not as such a prediction. If one has an intention, one's knowledge of that intention is, first and foremost, practical knowledge, a knowledge of the end, the purpose one has, and the means, the purposeful conduct one has chosen. We have here mixing of the empirical and the normative. In this case, what is to be done or what should be done, and also a mixture of a sense of means and ends. Both of these very complicated for modern social sciences. And we get a further explanation in a footnote in Natural Law and Natural Rights at the bottom, where he, in another context, Finis uses this phrase. He says, is to be as a gerundive, i.e. in the sense it has when we ask, what is to be done? Quid est faciendum? Thus, it can be understood as equivalent to ought to be across a wide range of meanings of ought. Finis here quite comfortable with abandoning an is-ought distinction. And I accept that I accept both points that have appeared already in this series, that natural law in its new natural law manifestation has often endorsed an is-ought distinction. This point made by Will Nolan, and also a point mentioned by Daniel Dehaan that we have to see differences between things like fact-value distinction, is-ought distinction, empirical normative distinction in the context of the arguments that play out at that time. So I don't want to get too much into either of those points, which are great points. But it's nevertheless the case that in formation of the notion of the central case of law, Finis is quite generous in discarding the is-ought distinction, and I think that's relevant for interpreting his notion of the practical. But what is the sort of challenge that Finis is dealing with as to why he is using these phrases of is to be or should be done to bring together a notion of intention and practical and knowledge of the end for the purpose that one has. A key opponent is the social theorist Max Weber. So I'll just read a quote here from Methodology of Social Sciences. There is and always will be, and this is the reason that it concerns us, an unbridgeable distinction among, one, those arguments which appeal to our capacity to become enthusiastic about and our feeling for concrete practical aims or cultural forms and values. Two, those arguments in which, once it is a question of the validity of ethical norms, the appeal is directed to our conscience. And finally, three, those arguments which appeal to our capacity and need for analytically ordering empirical reality in a manner which lays claim to validity as empirical truth. So this is a good distillation, I think, of Weber's general approach of separating things like values and culture on the one hand, secondly, things like ethical norms that appeal to conscience, and thirdly, the analytical ordering of empirical reality, which is basically what he felt he was doing in terms of social theory. So Weber being a key proponent of a normative empirical distinction as the foundation for proper social science and is endorsed throughout the academy at present, really under its distinction makes these three separations between values and culture, conscience, and analytically ordering empirical reality. And that separation basically renders impossible the notion of practical reason, even kind of phronesis, but specifically practical reason towards the complete community, which Finis believes is the central case of law and endorses. He would feel much of Aquinas' sort of progress and achievement in understanding the relationship of means towards ends on the social plane. So the view of the central case of law is essential for the workings of natural law theory. So I want to discuss it in this paper, the merits to understanding law in terms of a central case from a perspective that is tolerant and endorsing of social science methodology and the ability of social theory to complement the quest towards interpretation of the central case of law. The relationship of natural law theory to the social sciences has been tenuous at best, if at all existent. So most debate on natural law theory is happening within theology, philosophy, and law, in law, its place is thoroughly contested vis-a-vis the understood dominance of positive law as sort of the best way of perceiving the uniqueness of a legal system. And partly because of its such complicated and mixed reception within the legal academy, it hasn't really crossed over much into the social sciences, or what we broadly understand as sort of descriptive social theory. So this represents, I think, an opportunity missed so far by both sides for fruitful academic dialogue. The importance of engagement between jurisprudence and the social sciences for natural law is evident enough in the fact that the first chapter of Finnis's seminal work, Natural Law and Natural Rights, discusses how law can be approached through the social sciences. But unfortunately, the omission of a valid natural law social science methodology, that's basically what I would aim at, a natural law social science methodology, works to produce misconceptions of natural law theory and misdiagnose of what we might demand from politics for any given society. So what is the problem of communication that natural law theory has when you don't have a as I term a natural law social science methodology? It is that firstly, some people perceive natural law as to equate to a kind of biological determinism. This is how it's often sort of referenced by those who haven't read much recent stuff on natural law, and who instead have maybe been exposed through sort of, you know, strong arguments in favor of the natural traditional family, for example, in the case of marriage law debates, or those who would equate natural law as simply a sort of pro-life stance. That seems to be viewing us as avoid technology, affirm what is sort of natural biological, perhaps therefore animalistic, certainly don't play God, and don't transform our kind of base human nature into something that is unnatural. So this perceived way of viewing natural law theory comes under the counter argument that we are more than animalistic, which can take various forms. It can take the form of we are self-determining in politics, so notions of sovereignty or nationalism very much appeal to the sense in which the collective through history is more than mere individuals. This counter-argument is featured in Hegel's philosophy of history, where a sense of sort of spirit rises up and human freedom through history. It also comes under the form of associating a sense of the biological with base appetites. So it's sometimes seen as primitive in a sort of Hobbesian sense of the natural law being the state of nature, and therefore base instincts or selfishness being the overriding feature, which unfortunately complements with some people's simplistic framing of fallen nature through original sin being a sort of tendency towards selfishness or evil, which it must be what is meant by the natural, and therefore natural law is a corrective on an appeal to law as a corrective on our fallen nature, and therefore is paternalistic and inherently conservative. But overall, because of the sense in which our collective action is more than the sum of its parts and can move us towards progress, it is often thought that natural law's biological determinism will be a sort of step backwards, parochial in the quest for human flourishing. And the second way natural law is often pitted is as a sort of simply a form of describing human dignity universalisms, which is how I would count most people who are making a much better, more sophisticated contribution to sort of legal theory and social theory, aside from that first caricature. They will perhaps unfortunately be caricatured in terms of promoting human dignity universalisms, generally speaking, which is great. So examples are appeals to Universal Declaration of Human Rights being a form of kind of natural law theory. For example, using the term human dignity as describing the basis to all law and politics. So it mostly has in mind the common good, and it can lead, for example, to reconciliation between absolute human rights claims over basic human dignity like right to life, or freedom of speech or freedom of association, with socioeconomic rights, because all can be understood through a sort of general lens of human dignity. And evidence for a kind of general universalism through natural law theory is provided in rules we are felt to know in common, like do not kill and do not lie, or an understanding of Finnis's approach as exclusively one of the basic goods, which are somewhat universal. And so the role of law in a natural law theory is to promote and protect those basic goods. But this much stronger, I think, framing of natural law theory also comes under counter argument. So A, that societies are diverse, so it's impossible to sort of assume universalisms or bring universalisms to bear on particular societies, legal structures. Counter argument B, that human dignity underdetermines political priorities, because politics is about scarcity and forming priorities in the midst of scarcity, the more kind of economics lens, and therefore general platitudes on human dignity doesn't really give sufficient prescription on what needs to be done now and what would be wrong to do, though good, at another time. And counter-argument C, that law is practically significant where there is a lack of coordination. So we introduce laws where we have disagreements that need to be resolved, i.e. law is technique for settling disputes. So there's no way in which an appeal to general human dignity can serve the basis for the central case of law if law is practically significant in zones of lack of coordination. So this is the struggle, I would say, to which the approach in general of natural law theory is not helped by not having a natural law social science methodology that might be able to explore the way in which you have particular laws in particular societies that seek the common good and human flourishing as pertain to that society's political needs at that time. And that is, in a sense, the kind of realm of politics and the legislation of goods through law, which may not be fully determined by sort of biological or, if you like, metaphysical or philosophical anthropological truths, and may not likewise be fully determined by universalisms. So I want to suggest 4 sort of objections to sort of to forming a natural law social science, and these objections are basically to my own position. I hope that we can sort of use to explore the topic and hopefully overcome. But I do think these objections help sort of see the nature of the problem. So objections to using a concept of central case of law empirically for a particular society. Firstly, there is a lack of ability, it seems, to revise understandings of when a law is close or peripheral to the central case. This is a sort of common problem for those who do ethics of applying a sense of what is, just or unjust law. But here, because we're talking about a particular society, the problem is even worse, because a law may be just in general, or have elements of justice, but not be the central case of law for this particular society, given its particular challenges or needs. Secondly, there is often a misconception of the central case as a single end of practical reason, when a flourishing society exhibits diverse ends. So the contestation over our notion of human flourishing produces a problem here for interpreting the central case of law, because laws are instruments for doing particular things. And so when we describe in Aristotelian terms a need to sort of recognize the end of human purpose as happiness, we have a sort of a singular notion. At the same time, we know that the laws pertain to particular things, and even a notion of human flourishing can have sort of diverse activities. So it's difficult to ask the question of whether a central case of law aims at a single end of sort of what we say collective social happiness, or whether it has diverse ends towards the many aspects of make up a flourishing society. Thirdly, there's a lack of specificity of the extent to which the way laws are made, e.g. democratically, are material considerations for whether they lie within the central case, or whether the central case only refers to the practical reasonableness of the laws themselves once promulgated. This is a really important point, I think, for anyone who sort of wants to interact what we say is political science with natural law theory, which, as I say, is not really that common, but something I would definitely kind of promote. And the problem, simply stated, is this: that when you speak to ethicists, they will talk about, from a natural law standpoint, just and unjust laws, or good and bad laws, in terms of whether they are ethically good and right. But the fact is that in the body politic, we sometimes talk about laws which are unjust because of the way they were made. So we would say that a law is good when made democratically, and bad if imposed in an authoritarian manner. And so we would say some laws, though good on paper, are unjust in practice. So what do we do with that when we're trying to ask what is the central case of law in terms of practical reasonableness towards the complete community? Do we say that law is understood within the central case if it's made in the right way, or do we say if it's as a law is right, good, and just, regardless of how it was made, how it was brought in or promulgated? And the fourth objection to using the central case of law is the inappropriateness, it seems, in evaluating law in terms of practical reasonableness, given the inability of law to efficiently discriminate between the collective and personal moral development of individuals. And I would say, for me personally, this is the most hard one to overcome, because if you were trying to empirically do natural law theory, and in terms of a social science, you're looking at the way in which laws were orientated towards the common good. Now, the collective moral development is sometimes out of sync with personal moral development. For example, I may say society has a problem of alcohol. So we know British society, of course, is in the ditch and struggles every Friday night with the alcohol question. So if I bring in a law that looks like it's pertaining towards the common good, that may, for example, restrict alcohol consumption, this may nevertheless be out of sync with people's personal moral development. So there may be person A, John, who actually is not social enough. So he is too self-obsessed. He works late on a Friday night. sort of a workaholic. He never spends time with friends. And in fact, for him, it would be good to have a drink with friends on Friday night. From a personal moral standpoint, that would help develop him in terms of his friendship, his sociality, his generosity, therefore his charity. And so we have a law which we can't quite reduce in its evaluation to the effects it has on personal moral development of individuals, because that effect is mixed. So how do we efficiently discriminate between the collective and personal moral development of people when evaluating where the central case of law lies? Okay, so in the paper, I counter each of these four objections, and I find, I hope, that a central case methodology to law can provide a robust defense against each of them. And notwithstanding, I think treating their concerns is a useful exercise for pointing towards a more refined combination of natural law theory and social science methodology. Max Weber, for example, has had important impact on methodological discussions within jurisprudence, and yet the relationship between the Weberian approaches and the natural law school remains conflicted. And because I take Weber as foundational for the mission and project of modern social science, insofar as there is incompatibility between natural law theory and Max Weber's social theory, I basically take that as an inability to do any social science methodology through a natural law perspective. So there are good reasons, I think, for that conflict, namely the fact-value normative / empirical distinction that you kind of go one way or another on. But it's equally true that some clarity can be gained in terms of where the differences lie and what kind of project would overcome the Weberian defects. So I hope that discussing these four objections to a central case approach invites broader reflection on the relationship between modern social science methodology and natural law theory, specifically how the agreements and disagreements between the two approaches might point out a way in which the central case of law for a given society can be appreciated by a committed social scientist, if there was one. So let's kind of explore the terms of some of these objections. The commonly held jurisprudential methodology is that description precedes evaluation. So that is to say, that observing what the law is can be made before and separate to evaluating whether it is good or bad. So in contrast to this, natural law theory holds the evaluation of law to be a necessary component to describing what law is. Modern social science methodologies instead tend to affirm distinction between the facts of how things are and the normative values that inform whether the situation is right or wrong. The intention behind this position is to avoid the bias of the observer clouding what they are observing. So, for example, if I believe the Kurds are mistreated in Turkey, there's a danger that I sympathize with their cause when describing Turkish politics. My description is therefore less informative for an audience who seek a complete portrayal where each issue is put into accurate and representative context. The means it's perceived to avoiding this danger lies in a clear separation of fact from value, though the terminology, of course, differs depending on the type of social scientist. So for the economist, they want to avoid a mixture of the positive and the normative. For the political scientist, they want to avoid a mixture of the empirical with public policy decision-making. So the academy is supposed to set out the kind of the social science of the problem, and then the bureaucrat or the political class makes the decision based on the evidence. And for the sociologist, they seek to avoid a mixture of the empirical with value bias. So values are things that can be anthropologically interpreted among people that you study, but are not values yourself that you bring into your methodology. So to this general intention of trying to separate these things, the commitment of natural law theory to mix description and evaluation comes across as alarmingly problematic. Nevertheless, I think it would be naive to consider the natural law position as merely failing in communicating appropriately. Natural law theory does radically commit to crossover between the description and evaluation of human affairs. So they are right to be afraid. So there is for Finnis, quote, a mutual, though not quite symmetrical interdependence between the project of describing human affairs by way of theory and the project of evaluating human options with a view, at least remotely, to acting reasonably and well. The evaluations are in no way deduced from the descriptions, but one whose knowledge of the facts of the human situation is very limited is unlikely to judge well in discerning the practical implications of the basic values. Equally, the descriptions are not deduced from the evaluations, but without the evaluations, one cannot determine what descriptions are really illuminating and significant. The position, I think, is represented well in Richard Eakins, who's at St. John's College. Considerations of the jurisprudential ramifications of findings within language theory, spearheaded by Ludwig Wittgenstein, of course. So if linguistic meaning generally underdetermines speaker meaning, how can one accurately and consistently interpret law? Eakins argues that appreciation of the language used and its structure must be accompanied by awareness of the intention, something that is in turn reflexive of social meaning, context, and audience reception. As such, what a speaker means in uttering a sentence is what he intends to mean, which is a pragmatic fact identified by the hearer through inference as well as semantic decoding. Well, what does inference consist? So Eakins' acknowledgement of intention as a necessary feature for understanding law meets with natural law's theory in its affirmation of a necessary normative component to any social inference. The methodology is at base dependent on observing actors' purposes. The source of the approach can be found in Aristotelian natural philosophy, where movement is always understood as coming from something, going to something. Movement cannot be known without knowing where the object is headed, its end, aim, direction, or purpose. The ends of things are, in turn, best framed in terms of their nature. Physical objects have physically determined ends. Humans, on the other hand, who are by nature free, choose goods to obtain happiness. So as Finnis outlines in this quote from article Grounds of Law and Legal Theory, we should expect the application and even the meanings of central case and focal meaning to shift as we move from 1, natural orders, physical and other natural sciences, metaphysics and so forth, to 2, logical orders of thought bringing order into its own operations, to 3, the order of morally significant deliberation and action, and 4th, to the arts and techniques that bring order into matter within our control. We should expect the centrality of central cases in the natural and or metaphysical sciences to be grounded in kinds of reasons, among them doubtless statistical frequency, notably different from the kinds of reasons that ground the centrality of central cases in the domain of self-shaping and community shaping morally significant action. A social science methodology that ignores, therefore, intentionality in human affairs misses a large part of the story of the meaning and direction of society at the level of community shaping morally significant action. Thomas Aquinas systematized the Aristotelian approach and provides the following epistemological explanation of what is going on, an explanation that would no doubt jar with modern social scientists committed to a fact-value distinction. So a quote from Aquinas. Truth consists in the equation of mind and thing. Now the mind, that is the cause of the thing, is related to it as its rule and measure, whereas the converse is the case with the mind that receives its knowledge from things. When therefore things are the measure and rule of the mind, truth consists in the equation of the mind to the thing, as happens in ourselves. For according as a thing is or is not, our thoughts or our words about it are true and false, or false. But when the mind is the rule or measure of things, truth consists in the equation of the thing to the mind, just as the work of an artist is said to be true when it is in accordance with his art, speaking almost to the notion of practice in MacIntyre. Now, as works of art are related to art, so are works of justice related to the law with which they accord. Therefore, God's justice, which establishes things in the order conformable to the rule of his wisdom, which is the law of his justice, is suitably called truth. Thus, we also in human affairs speak of the truth of justice. Whoa, when I read this, I was so shocked. So what's happening here? Aquinas is distinguishing between, firstly, knowing by making our minds conform to the object, which is how we would normally understand science. And secondly, knowing by making the object conform to our minds, something which is basically indigestible, I think, for modern social sciences. For the average social scientist, that second one is absurd. However, Aquinas gives us as example not the scientist, but the artist, for whom truth consists in the equation of the thing to the mind. This is not a declaration of the relativity of truth for art, I hope, but it's a consideration of how art can reveal the deeper meaning of things through the manipulation of the physical. So art does impose an order on things which otherwise did not have that order, but it is in doing so revelatory of deeper truths. But importantly for jurisprudence, Aquinas furthers that this relationship of art to truth has parallels in law. The truth of law lies in how humans make it so as to mete out justice. The same is clear in Finnis's consideration. So to quote from Finnis again, for our purposes, physical, chemical, biological, and psychological laws are only metaphorically laws. The similarity between our central case and the laws of arts and crafts and applied sciences is greater. In each case, we are considering the regulation of performances by self-regulating performers whose own notions of what they are up to affects the course of their performance. In this way, just as an aside, it's worth knowing the approach answers Alistair MacIntyre's criticism that social science methodology operates under a pretense that the causes for social trends cannot be observed and acted upon by the very subjects under study. So this approach at least meets that objection. So natural law theory goes in the opposite direction by consciously adopting the self-direction of agents as an explanatory factor for interpreting social change and the meaning of law. This methodological position is very far from arbitrary appeal to normative values as a criteria for saying when the central case of law applies and when not. It is a thoughtful methodological response to a persistent and previously unanswered inconsistency in how self-directed action is considered within social theory. Nevertheless, a concern is still apparent. Even if the social scientist includes self-directed action within an interpretation of the central case, how might the central case of law overall be evident? Indeed, it cannot be that noting human intentionality is sufficient for identification of the central case of law, as the result would be purely voluntaristic for the notion of the common good towards which society is being directed. That is a sort of might is right sort of approach. And I do think it is a struggle for those who have sort of been exposed maybe in their doctorate to Finnis's framework of central case of law as practical reasonableness towards the common good. They have often entered into constitutional law questions whereby they have taken as their basic point the affirmation of human intentionality as sufficient for identification of the central case of law, particularly with respect to debates on sovereignty. So students of Finnis exposed to natural law theory then affirm principles of sovereignty as being grounding for the nature of law, vis-a-vis others who take in theories of universal human rights from outside and engage in progressivist judicial activism towards the Bill of Rights or the constitutional law in general. So I can see why they've done that move. It kind of makes logical sense. But if we were simply to say that social science treatment of natural law theory would better capture human intentionality in the making of laws, we would be in danger of being purely voluntaristic on the notion of the common good. So Finnis, on the other hand, maintains that the appeal to the standard of the morally right-minded person is not viciously circular. The basis to this is his notion of unity between what is good and what is true. Philosophically, it may be consistent to define goodness and truth in an interdependent manner, but conflicts it tends to be with the social scientist commitment to a fact-value distinction. Here, read that it's equivalent to a truth-goodness distinction. And that's basically my problem with the fact-value distinction, is when it amounts to a truth-goodness distinction at its core. Importantly, even if the social scientist rejects a fact-value distinction and commits to principles of practical reason, the question arises as to what the substantial character of truth consists of, which he or she can use to interactively inform participatory ideas of the good on the social landscape. So even if the social scientist accepts that there is no basis to a methodology that ignores a priori an aim or purpose to human affairs, that does not provide a positive example of the methodology that includes the ends of human happiness and a self-sufficient, flourishing society. So there are four options that the social sciences provide, which I don't have time to go into. One is the variant ideal types to navigate this problem of identifying overall sort of aim of society. And this comes under fire, obviously, for endorsing the normative empirical distinction that Weber is working with. But basically, his notion of the ideal types takes on an idea of what is a pure categorization. So, overall, it's, it's very German. But his definition of ideal types is, quote, an ideal type is formed by the one-sided accentuation of one or more points of view and by the synthesis of a great many diffuse, discrete, more or less present and occasionally absent concrete individual phenomena, which are arranged according to those one-sidedly emphasized viewpoints into a unified analytical construct, Gedankenbild in German, it's easy. In its conceptual purity, this mental construct, this Gedankenbild, cannot be found empirically anywhere in reality. It is a utopia. Historical research faces the task of determining in each individual case the extent to which this ideal construct approximates to or diverges from reality. So, difficult because being sort of a mental construct is not necessarily empirically observable, so not very palatable for a kind of critical realist approach, but also because it methodologically endorses a fact-value distinction, it can't fully capture the sense of human intentionality towards the common good that the central case of law would typically feature under natural law theory. One could instead redeploy quantitative methods in terms of finding out what is the normal or average in society. So, for example, average norms, average sort of ideas of the good through a sort of normal distribution of the values that society has. I'm quite sympathetic to this overall approach. But even there, methodologically, it struggles because you need to work with the notion of the good if you are to see others' notion of the good, which is partly MacIntyre's criticism of the social sciences, of trying to create a rubric of valuation that the observed cannot participate in equally. And so there's certainly the case for a need of a sense of human goods prior to deployment of quantitative methods. The third option is to take a kind of notion of the common within common law. So we talk about common sense, and we talk about the common law is built through case law, and in this sense, arriving at common notions of the good towards which the laws facilitate human flourishing. This struggles in terms of common law only being a part of how we understand the law. That of course, within a common law system, much is built up through case law, and in that sense, the moral wisdom of the jury or the judge, but it is also much is legislated on in terms of political priorities. So it doesn't fully capture the sort of political direction that is given through legislating, plus the fact that common law tends to be generated in areas of the need to settle disputes, which is not necessarily central to how we understand human flourishing. It may just be where there is particular disagreement in that society. And so a fourth option that I want to kind of suggest sort of by way of close is to say that we need to have a notion of social virtues oriented toward unity if we are to combine empirical and normative appreciation of the central case of law. This notion of unity, I'd like to sort of build from Aquinas's sense that the body politic aims towards unity, and I think this notion of unity can be very useful for understanding these four objections. So we understand in this reading social virtues to be habitual dispositions toward unity that normatively arrange persons toward a complete community. And so towards the objections, I feel this can be quite useful. So the first objection was that we have a lack of ability to revise understandings of when a law is close or peripheral to the central case. And I think what can aid in that is a sense to which it brings about social unity, and in that sense, common purpose, building on work on law as a coordinating instrument for society. Second objection, that misconception of the central case as a single end of practical reason when a flourishing society exhibits diverse ends. While this is true, an aim towards unity as overarching for the central case of law helps see and identify how diverse ends can translate into a single end of happiness or oneness with God, salvation, through diverse sort of pursuits. Thirdly, this objection of a lack of specificity of the extent to which the way laws are made are material considerations, whether they lie within the central case or whether the central case only refers to the practical reasonableness of laws themselves once promulgated. If we see that the end of the body politic is unity, then we are receptive equally to whether laws are just in the sense of giving each his due, and whether the way in which they were promulgated was a just sort of method or not, because of the need for unity, needing to bring people together, not just in outcome, but also in the process of decision making. And the fourth objection, the inappropriateness in evaluating law in terms of practical reasonableness, given the inability of law to efficiently discriminate between the collective and personal moral development of individuals. Here again, I feel there's scope for introducing or a kind of thick notion of unity within social science methodology, and therefore for help identifying the central case of law, because if you take unity as a good, it is a good both personally and collectively. And so in this sense, one's personal moral development is affected by a lack of unity within the body politic. And this makes relevant as to why the law can be just and good, even if it's not the particular rule that one would self-determine for one's own virtuous development, but does bring harmony, greater harmony with the group as a whole. So I'll leave it there, and thank you so much for listening. Over to you, Michael.